afternoon. My name is Oliver Westmoreland. I am the Senior Immigration Advisor at GSN Immigration. I'm also an OISC Registered Level 3 Advisor. Please subscribe to our YouTube channel and click on the bell icon so that you can continue to watch our extremely interesting videos about UK visa and immigration advice. Today's topic is this: reasonable grounds applications, let me clarify, late reasonable grounds applications for the pre-settled status EU settlement scheme. Now, I'll just summarise this very, very briefly indeed. The EU settlement scheme was created sometime in 2018. It replaced the old European free movement law. The EU settlement scheme is part of British law, is fully part of British law. It's not a hybrid, it's not a quasi thing, fully part of British law. People were able to, Europeans and their family members were able to apply for pre-settled status. This was a new status which replaced previous status, which was called EEA residence card. Europeans or EEA nationals and Swiss nationals were able to apply, and their family members were able to apply for the scheme. This would give them 5 years leave to remain in the UK, and it was free and it was good. The deadline to apply for this was 30th of June 2021, and I have to tell you that some people haven't quite got there yet. Some people haven't quite applied because of this reason or another reason. Home Office didn't want to penalise people too much, and they made a scheme. It's called a reasonable grounds application. If somebody could apply for pre-settled status, that they fit the rules for pre-settled status, if they could or might be able to apply for pre-settled status, but they haven't done so yet for whatever reason. Now, this was a long time ago. This is 2 or 3 years ago, isn't it? But if for whatever reason they haven't applied, the Home Office has created a scheme, reasonable grounds application. Applicant says, I'm sorry, I'm late. Here's my application, but I have good reasons. This is what reasonable grounds is about. The rules are quite hard and quite strict, and it's not going to be easy now to make a successful application, as the Home Office quite reasonably say in their policy guidance. As time goes by, it's going to be more and more difficult to succeed because you're going to have to find stronger and stronger reasons and excuses. But also somewhere I read today, actually, there is no time limit on this. It goes on forever. In 20 years' time, we might still having people applying under the reasonable grounds EU settlement scheme. So there we go. But it is quite hard and harsh, I would say, pretty much more or less. The Home Office will only accept certain types of reasonable grounds, and they give examples. As always with the Home Office, serious illness, that could be a good reason. Lack physical or mental capacity. You're the victim of part of an abusive or controlling relationship. You can't do what you want, you're not free to act. But, very importantly, the Home Office say, quite reasonably, I would think, that could be a reason for not having made the application on time, but it has to be a reason that works up until now. You know, if you're making the application now today, it has to be a reason that works up until now. It's not enough to say, well, I couldn't make it on 30th of June 2021 because I had this issue and this issue. But you've got to show that that situation, whatever it was, it continues until now. So now I can apply. That situation's just finished. Of course, this makes things a lot more difficult. It's not just showing that you couldn't make the application on time. It's also showing that you couldn't make the application on time and you couldn't make it until now. I think on the whole, it's fairly reasonable. Home Office are pretty firm on this. They say, didn't know about it. It's not a good enough reason. And the Home Office gives all sorts of justifications. They say there's been so much information in the media and around and about. No one can say that they didn't know, really, not in most cases. On the whole, didn't know is not going to work. There could be exceptional situations. Home Office always says this ringing phrase, every case depends on its own facts. They say that a lot, but generally, in overarching way, I didn't know about it is not going to be good enough. The Home Office do give a few examples of what might be good enough. Don't know. The examples they give slightly obscure. you were given incorrect advice by an employer or a landlord. It doesn't mention lawyer, but you were given incorrect advice by an employer. Normally we get blamed for everything, but not this time. They give that example. Another example they give is quite interesting. I'm amusing Mr. Shah quite prodigiously. Another example they give is quite interesting. You travelled in and out of the UK a few times and you were never challenged or questioned at the border. Maybe could work. Another one example they give, I'm not sure if it's a really good one or strong one, but you had a spouse or partner who had properly applied for leave and you thought you didn't have to because your spouse had, you thought, well, it didn't matter. Those are the examples they give. But let me be honest with you, I think reasonable grounds applications after 2.5 years or whatever it is going to be difficult. You probably want to get a good lawyer to help you with this. Mr. Shah, I'm sure you're brimming with questions.
Yes, thank you so much for elaborating on this quite a lot. And believe it or not, there are lots of people, like you said, in a situation like this.
I heard there are quite a few people who still haven't quite got round to it.
Exactly. Now, if there is a scenario like that, which you mentioned, there is no solution to that, saying, okay, I didn't know, I didn't come across any TV advert, or I didn't hear about it on radio, I didn't receive any email from the Home Office, nothing.
Well, you wouldn't receive it from Home Office. That wouldn't work. And Home Office said that doesn't work. You don't watch TV or radio, so it doesn't work. It's not a reasonable. I mean, the words reasonable grounds, that is not reasonable. Maybe fairly or unfairly, but that's what they say and that's what they think.
Sure. In that situation, would those people have to look for alternative visa routes to continue to remain in the UK?
Mr. Shaw, let me be completely straight with you about this. Somebody who hasn't applied, who should have applied for pre-settled status and hasn't applied, today they're an overstayer. They've got no legal status in the UK.
Wow.
Overstaying, as you know better than I do probably, you've been around a few years obviously, overstayers, they're not technically, legally they're not allowed to work, they're not allowed to hold a bank account, they're not allowed to hold a driving license, they're not allowed to rent a property. Today these people are overstayers, and if they don't make an application they just remain overstayers. I'm not going to say that they're all going to get removed because it doesn't really work like that, does it? But such people are all overstayers. If they can't make a successful application, they remain overstayers, and God knows what will happen in the end. They're here with really little or no status at all.
Wow.
And it's as bad as that. And as you also know, if you're an overstayer, it's going to be quite difficult to apply for a visa in the UK.
Yes, indeed.
You might end up going back home, but you still might get hit by the rules. These people are in a difficult situation now, and until such time as they address their situation, they're going to remain in a difficult situation.
I understand not only these people, but also perhaps their landlord, their employer, maybe in trouble as well.
Yeah, could get a proper civil penalty, or in a bad case, criminal prosecution.
Wow. If we have parents who may have applied for themselves and may not have applied for their kids, thinking we are applying, same rules will just be passed on to them, could that be some sort of reasonable ground?
Yeah. If you're a child, or you were a child at the time, your parents messed it up, that is probably going to be a stronger application. Because the child can't really take responsibility for the actions of the parents in a general way in English law.
Sure. If somebody was in prison, for example, and they couldn't make an application, they didn't hear about it and stuff like that.
Well, you've got two separate issues there. If someone's in prison, they can make an application, I guess. They should have support in prison. I didn't hear about it. If they didn't hear about it, really and truly, I suppose that could be a good argument. But if you're in prison, you should get support, shouldn't you, from the probation service and so on and so on. But I suppose, I mean, I haven't come across this situation in my work, but I suppose if you're in prison and you really didn't hear about it, I suppose that could be a strong application.
Sure. And if someone is in that situation and technically overstaying in the UK?
Well, listen, Mr. Shah, either you're an overstayer or you're not. There's no such thing as technical overstaying. You are or you're not.
Sure.
And don't forget, knowingly overstaying is a criminal offence in itself.
Wow.
It's not usually prosecuted, but it is actually a criminal offence, knowingly overstaying.
Hmm. So if someone is overstaying and they just recently find out about it,
Because they switched on their radio or something.
maybe they watch our vlog and they get to
Exactly,
know.
very good point. Yeah.
That means they if they have a sponsor for their work visa, could they go back home, make an application? However, the general grounds of refusal will apply to them.
Yeah, but don't forget, a work visa applicant gets all the sanctions of Part 9 of the immigration rules. If they've overstayed very significantly, they're not going to be able to make a successful application for a while. And because it's a working visa, that there are no exemptions, or you can't slip under the rules.
Wow. So someone in similar rules, if they were to apply for a spousal visa, would it be a different
Now,
outcome?
that's different. Spouse visas, as you will know, come under Appendix FM of the immigration rules. It's a lot more lenient because it's a sort of Article 8 human rights flavour sort of application. That is different. Working visas and family visas, they get treated very differently by the rules.
Okay, brilliant. That answers a lot of questions
It
and a
certainly
lot of
does.
different scenarios.
Wasn't
Um,
easy.
yes, exactly. We thank you for today's vlog
It's my
and
pleasure.
we see you in the next one.
See you soon. Bye bye.